all that bandwidth we have over here. Okay. Good now. Ms. Palmer? Ms. Palmer. Do you have something?
Yes, Your Honor.
It's weird to see you
Brandon
standing in that
Collins.
one. I'm sorry?
Oh, Brandon Collins is with
Uh-huh.
Brett Harrison via Zoom.
Okay.
Thank you.
Mr. Harrison. And you're
Morning.
here? Oh, there
Mr.
he
Collins is in the courtroom, Your Honor.
All right, this is cause number CR 21-0322-392, the state of Texas versus Brandon Collins, and this is set today for discovery status.
Your Honor, we had outstanding discovery. It was requested by the defense, and we have now a copy of a dash cam that I have not provided. I was going to provide this morning, and a 2-page crash report that has not been provided. We are
We were
still,
waiting for something last month when we did this.
we are. So we have those 2 things now, and then we are still waiting on an additional crash reconstruction that has not been started yet from Sergeant Massey. So as soon as that is provided to us, we will provide that. In addition, we have a trooper that's still at the border who believes that he has a flash drive that we need to turn over. So I would ask for one more discovery status.
Mr. Harrison?
Well, certainly I need that information, so I don't have any objection to having another discovery status. I appreciate the DA's office diligence in getting us this material that we've requested. They've been extremely good about that, so I appreciate that.
November 3rd, 1:30. Is that good with everybody?
Just 1 second, Judge.
Yes, sir.
That should be fine, Judge.
November 3rd, 1:30, Mr. Collins. Remember, any conditions of bond you're on, as soon as you receive your reset notice, you're free to go.
And Your Honor, we'll have the disc available for Mr. Harrison to pick up, or if you'd like to mail it, if you'll just let us know, we can send it to him.
And Judge, we've been reciprocating. We've been sending the district attorney's office information that we believe to be mitigation as well on a periodic basis.
All right. Thank you, sir.
Thank you, Your Honor. That's all I have. May I be excused?
Sir, good to see you.
Thank you. Thanks, Jenny.
All right, Ms. Altier.
Yes,
ready
Your
when
Honor, I'm
yours?
present. Yes, Your Honor.
All right, I'm just gonna start at the top. Is that what you want to do?
Yes. Can you hear
Oh,
me?
it's this afternoon. She has a lot of cases. I know I saw some. I got you. All right, this is James Sockwell. This is cause number CR 21-0453-392, the state of Texas versus James Sockwell, and this is set for pretrial. Any pretrial from the state?
Standard motion for discovery, Your Honor.
No objection, Your Honor.
Granted, and then on behalf of Mr. Sockwell.
We have no pretrial.
All right, Mr. Sockwell, then the court deems pretrial is held. Your next court date is status, which is typically your last time to resolve your case before it ends up on a trial docket. And that is October 7th at 1:30. Does he have an offer?
He does, Your Honor, 7 years TBC.
7, okay. All right, well then we'll see you back at status in October. Thank you, sir. Is
Thank you,
that all
Your
you got,
Honor.
Ms. Altier?
That's all this morning. I'll be there this afternoon.
Okay,
Thank you.
Mr. Mills.
Yes, sir. I got you.
Mr. Bowman, you passed your test. You're free to go. We'll see you in your next court setting. Who do you got? Sorry about that. No, who was it? Want me to start at the top? Rayburn?
That's fine.
Mr. Rayburn, come on up. This is cause number CR 21-0418-392, the state of Texas versus Jack Rayburn. And this is set for pretrial, any pretrial from the state.
Standard motion for discovery, Your Honor.
No objection.
Granted. And on behalf of Mr. Rayburn,
Judge, I did file a motion for a speedy trial that Mr. Rayburn requested.
this is
There-
attempted cap murder case at the top, right?
Yes, sir. It's all under one cause number, I think. But
It is.
there was
not multiple counts.
Yes, sir. I think that's right. There was a discovery issue last time we were here, Judge. There was the alleged offense took place at one location. I have all the discovery from that, I believe. But then the arrest of Mr. Rayburn took place at a different location. And I would assume that there were some dash cam videos or some sort of video. There were numerous law enforcement officers out there that made the arrest, and I don't have anything from the arrest location. And I think Mr. Strong was going to check into that and see what was out there. I don't have anything from when the arrest took place, and that's what we were requesting.
Investigator Quintanilla looked into that. He has gotten those discs. We got them in our office earlier this week. So Mr. Mills, we'll get you some copies of those and get them to you, or have them available to you at our office. But we have received those discs.
And as far as after those discs, is there anything else that you think's out there?
That should be it, Judge.
Okay, and then Mr. Mills, once you get those, you might lead you to
Right.
something else, but for right now, the state believes that's everything.
Okay, sounds
But
good,
here's what
Judge.
I'm gonna do. Mr. Rayburn, I know you've asked for a speedy trial,
I
but,
asked for another motion too, but I asked him to file a motion for suppress evidence.
well, he don't have all the evidence.
I know, that's the problem. I mean,
Well, no, you can't suppress it if he don't have it to look at it. So let him get that evidence and then look at it and talk with you, and he
Can I-
may.
can I speak freely again?
Well, please don't interrupt me while I'm interrupting you. Just hold on a second. So let him get all that stuff,
All right.
and then if he needs to, now you had something to say.
Well, I mean, I filed a motion. I mean, agreements with the state. I mean, he's been my lawyer for 6 months. I can't get him on the phone. I've got him on the phone twice. He told me he's gonna come visit me 5 times with the evidence that he does have. I mean, I got evidence myself
Right.
against the officers of that jail. I've been assaulted. I was in a cell for 47 days without a hospital. I had 3 fractured ribs, a lung, whatever. And even the jail said that I didn't have I got all the evidence on it. And I asked him to come to the jail so I could show him this evidence. I'm trying to talk to him freely as a lawyer, but I filed a motion with the bar, a grievance.
Right.
And I'm asking, I filed it on the docket, the withdrawal council. And it ain't been addressed yet.
I haven't seen it. I will tell you this, is that I can tell you've got a really good lawyer here. And he's a really
I
good
can't
trial
talk to
lawyer.
him.
They all are, or they wouldn't be on the list. Here's the deal, though. This Chinese virus that was created in China and brought over here,
Yeah.
that has caused our jail to shut down visitation. I just talked with the sheriff the other day. I think they just opened it back up recently, right?
I'm not sure, Your Honor.
And so he couldn't come
I mean,
see
he
it.
told me he's gonna bring the evidence today to show me what they do have. I mean, he can't even show up for court.
Right. Well,
Judge, if
go ahead.
I've been having problems with Mr. Rayburn from the beginning. I thought it was getting better. If he's filed a grievance against me, I'll just file a motion to withdraw. He's obviously doesn't think that I'm trying to help him or do anything for him, and this is just headed nowhere good. So if he wants another lawyer and he's filed a grievance against me, I'll be happy to file a motion to withdraw if that's what he wants me to do.
Well, here's what I'll do. The deal right now, sir, is this coronavirus has everything such in a mess. We're just trying to hold the line. There's 20 school districts in East Texas shut down today. We're trying to hold the line and keep things moving. And I appreciate the fact that you're in jail and you want a trial, and I want to give you a trial. But I've had 2 trials in the last 2 years because the government saw fit to shut me down. That's just the way it is. So I'm at their whim too. So here's what I'm going to do. I'm going to reset this for October 7th. Now that the jail's opened up and hopefully things are going right, I'll allow Mr. Mills to file that motion. If y'all can't get things together, I'll hear that motion in October or sooner if we have to. Does that sound fair enough?
Can I say something?
Yes, sir.
I apologize. No disrespect. You know what I'm saying? I'm fighting for my life. I didn't do this. You
Well,
know what I'm saying?
You're presumed
And,
innocent to me as you
And I
stand
can't
there.
even talk to my lawyer. I can't even get him on the phone. I need somebody to at least call on the phone. I mean, it's a free
Right.
phone call. I mean,
I got you. Well, like I said, if he wants to file that, see if y'all can work it out. If not, I'll hear it October 7th.
Yeah, and just for the record, Judge, I talked to Mr. Rayburn yesterday or day before yesterday. on the phone.
2 times in 6 months. He's lied to my wife. He's lied to me. You know, before this, they took their visitation away from us.
You had something?
I was gonna ask Judge, are we gonna set that for pretrial again so that Mr. Mills can review those discs, or what do we want to call that October setting?
I'm going to call the October setting pre-trial, and then if I have to hear any other motions, I will. If y'all need to get in court sooner, we're here.
And that was October 7th.
Yes, sir.
At what time, Judge?
What time? 1:30.
Do y'all have any evidence on the property that was taken at the
We're gonna
arrest?
ask your lawyer that.
He don't ask, he don't ask.
You have a seat, Mr. Rayburn. Thank you. Next is Floyd Smith. All right, it's cause number CR 21-0497-392, the state of Texas versus Floyd Smith, and this is set for pretrial. Any pretrial from the state?
Standard motion for discovery, Your Honor.
No objection.
Granted. And on behalf of Mr. Smith,
No pretrial, Judge. I've received all the discovery and a plea offer as well.
all right, Mr. Smith, then the court deems pretrial is held. Your next court date is October 7th at 1:30 for status, and that's typically your last day to resolve it before it ends up on a trial docket. Okay, sir?
Yes, sir. But I have a question. I mean, like the other fella, I haven't had to be talking to Mr.
I understand. So we'll just take that up in October if we can, because Mr. Mills not
I mean, I know he's a good attorney, but I just haven't had a chance to talk with him.
attorneys are busy right now. Everything opened up. They got a ton of cases.
So all I'm asking is before I run the trial, let me have a chance to talk with him.
I got you. Yes, sir. All right, we'll see you in October. Willie Thomas. Mr. Thomas. Cause number CR 21-0111 and 0474-392, both styled the state of Texas versus Willie Thomas. And both of these are set for pretrial. Any pretrial from the state?
Standard motion for discovery, Your Honor.
No objection.
Granted. And on behalf of Mr. Thomas,
Judge, I did file a motion to suppress in the PCS case that we'll need to get. I'll get with Mr. Inslee and get a setting on that, I guess. But we probably are going to have a hearing on that.
okay. All right, well then, I'll let Kevin, we're not gonna set it now. You have to look at the calendar. All right, so Mr. Thomas, we're gonna have a hearing on a motion to suppress on one of these cases. And so I'm gonna deem pretrial is held, at least for right now, set it for status for October 7th at 1:30. And so I'll either see you then, unless that motion to suppress is set sooner, I'll see you then. All right. I think that's all you got, Mr. Mills.
Thank you, Judge. I'll see you this afternoon.
Yes, sir.
Thank you.
Anybody else ready?
Ashley Haley here, sir.
Ma'am, please mute your video or mute your audio and your video. Oh, you are? Oh, okay. Well, come on back, Miss Haley. You're all right.
Yes, sir.
By the bondsman, making informed Kevin that apparently she's in Mesquite, had a baby in the last few days.
She's got it in her hands right there.
Okay, there's exhibit A.
That's a realistic, that's a real exhibit number one. That's a realistic looking baby doll. If it's not real.
Apparently she didn't have-
Baby alive.
Actually, she could do it by herself. I guess I just found out about this morning, so.
Okay, I'm trying to find the case.
Oh, yes, I'm sorry.
Here it is, right here. All right, this is cause number CR 21-0491-392, the state of Texas versus Ashley Haley. And that is set for pretrial. Any pretrial from the state?
Standard motion for discovery, Your Honor.
There's no objection.
Granted. And on behalf of Ms. Haley.
No pre-trial today, Your Honor.
All right, Ms. Haley, the court deems pretrial is held. Your next court date is October the 7th at 1:30 for status. And I need to see you here on that date, okay? Unless you've got COVID or have symptoms. You hear me?
Yes, sir.
All right, we'll see you in October. You can log off now, man.
October 7th.
October 7th, 1:30. Just stay in touch with Mr. Harrington.
All right, thank you.
Ma'am, you're welcome.
Your Honor, Mr. Berry for pre-trial, he's in custody. I'm ready on that, Your Honor.
Who is it? Mr. Berry?
Berry on page,
Oh, I see it. Michael Berry, come on up. Please today. They're working on it, please today. I think Mr. Castleberry has one. All right, this is cause number CR 21-0459-392, the state of Texas versus Michael Berry, and this is set for pretrial. Any pretrial from the state?
No objection.
Granted, and on behalf of Mr. Berry.
No formal pre-trial date.
All right, Mr. Berry, the court deems pretrial is held. Your next court date is for status, and that is October the 7th at 1:30, and that's typically the last day to resolve your case where it ends up on the trial document. Do you have an offer?
I think this is Kenneth's case, I believe.
It's now mine.
Was now it's his case. He was talking about an offer on this case. There's a subsequent case, so I don't think there's been an offer at this point. So,
Okay.
New ones, right?
yes,
Another indicted case?
yes.
Okay.
So,
All right.
no, sir. We're still talking.
We'll see you in October, Mr. Berry. You all right?
If I can circle back around.
Yes, sir. Good thing we sent her to the doctor yesterday. Can I tell her about you tested negative? She's negative for COVID. She tested yesterday. It's not COVID. We checked. And the court staff tested just about a week or so ago. Mr. Weiner, you ready on anything? Okay, I'm gonna go through the docket then and call those that have not been called yet. If you hear your name, just let me know you're here. Ryan Bennett. All right, gotcha. Mr. Bond, I see you. Carlos Mejia. Sure. Mr. Mejia, come on up. Did I call AC Haley? I missed that.
believe so, John.
AC Haley?
No, he's on the web. I spoke with him yesterday and we were trying to work out a deal. Kind of just be confused about something, but he's on the web.
Okay.
We're making close to this.
All right, this is cause number CR 21-0157-392, the state of Texas versus Carlos Mejia. And this is set for pretrial, any pretrial from the state.
No objection.
Granted, and on behalf of Mr. Mejia.
Speaking with Ms. Pace, I believe she's. What do you think?
Sure. So, Your Honor, we have requested discovery from several medical facilities, from several counselors, and also from law enforcement, things that we discovered that we don't yet have. So we would ask for at least a 60-day reset to try to gather all of that information and give Mr. Harrington an opportunity to review it.
It's my understanding, I think they just received it yesterday or something. Right? There's also maybe some issue about a statement that she's looking into.
That's correct.
I know you can't change the past, but like if you have these SART teams and then at the beginning they're involved and then everybody knows. That's what we used to have back in the day. It's called a SART team. I don't know what it's called now. Sexual Assault Response Team. And so when all these counselors notes and all that, everybody's already involved in the beginning. And then anyway, just an idea. But I know you can't change what happened in the past. 60 days. November 3rd, 9 a.m. Mr. Mejia, you're the one in jail. You're all right with that? Okay, well then we'll see you back in November. 9 a.m.
My paperwork's ready. Whenever you're ready, Judge.
I'm ready.
Page 8, Brandon Mcclure.
Mr. McClure, come on up. Just one, please.
It is one set of papers, Judge.
All right, this is cause number CR 21-0253-392, the state of Texas versus Brandon Scott McClure. This was set for discovery status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. McClure,
We're ready, Judge.
sir, is your name Brandon Scott McClure?
Yes, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, Your Honor.
Is this a multi-count indictment? Can I see the indictment? The indictment.
Believe it's.
Just give me the
I
file.
don't think the PCS itself was multi-count, but some of
This
the
is a
other ones are
different
being-
case.
It
Okay,
is. It's
I
being
got it.
considered.
I see it now.
Yes, sir.
All right, and are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance?
Yes, Your Honor.
If I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Now you can lower your hand. Mr. McClure, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, Your Honor.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, Your Honor.
And Mr. McClure, have you ever been treated for any mental health or emotional issues?
No, sir.
Is that a positive? A no, sir?
That's a positive.
Okay. And so do you understand what's going on in here?
Yes, Your Honor.
And Mr. Weiner, do you believe your client is competent?
I do, Judge.
And the court finds that he is. Mr. McClure, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No. Your Honor.
But do you understand the charge?
Yes, Your Honor.
Well, as indicted, that charge is a state jail felony, which carries a punishment range from 180 days and up to 2 years in a state jail facility and a fine of up to $10,000. Do you understand the range of punishment?
Yes, Your Honor.
And the plea bargain?
The state is recommending 4 years deferred adjudication probation with a $500 fine, $365 court costs, $180 lab fee, and all standard and special terms and conditions of probation. This offer would be taking into consideration an indicted burglary of habitation and burglary of building and an unindicted PCS case.
Is that your understanding of the plea bargain, Mr. McClure?
Yes, Your Honor.
Is that your understanding, Mr. Weiner?
Yes, Your Honor.
Well, Mr. McClure, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Weiner?
Yes, Your Honor.
And did you sign the front and the back?
Yes, Your Honor.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with
Yes,
Mr.
Your
Weiner? Did you sign that second page?
Yes, Your Honor.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Weiner?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, Your Honor.
You want to do this plea bargain?
Yes, Your Honor.
Then I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I'll hear the evidence.
State presents an offense report, Michael Morton compliance and lab report, Your Honor.
Your Honor, we've previously received, reviewed, and have no objection to any of the state's offers.
Admitted.
State rests and closes, Your Honor.
We rest and close as well, Judge.
All right, Mr. McClure, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, follows the plea bargain, places you on community supervision for a period of 4 years. You do have 1 day credit as to any sentence you may eventually have to serve, and orders you to pay your fine, court costs, and lab fee. And Mr. McClure, have you ever been on probation?
Yes, sir.
Did you successfully complete it?
Yes, Your Honor.
So you know what it takes, right?
Yes, Your Honor.
Do you know what can happen to you if you don't successfully complete this community supervision?
Yes, Your Honor.
What can happen?
I can serve up to 2 years in state jail,
And do you know how state jail time is served?
day for day.
Day for day, that's right. Here's what can happen. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail. And you only have 1 day credit. You understand that?
Yes, Your Honor.
So would you agree with me? It's extremely important you abide by these.
Yes, Your Honor.
I hope you do, sir. Good luck to you. You need to see probation.
That's all I have. Maybe excuse, Judge.
Yes, sir. See. All right, where did I stop on the docket calling it through? Said, Mr. Harrington's clients. We didn't handle. Shelley Riggins. Are y'all ready or are y'all still talking? I'm just checking to see who's here.
Yeah, Your Honor, I'm Andrew Howard.
Are y'all ready for discovery status?
Yes, Your Honor, I've been talking with the prosecutor and she's made an offer, so what we're gonna do, I think we're gonna pass it one more time.
Okay,
Come back.
well, let's go ahead and hold discovery status then.
Okay.
Ms. Riggins, come on up. Can I see the docket sheet? All right, this is cause number CR 21-0386-392, the state of Texas versus Shelley Riggins, set for discovery status. State.
Everything has been turned over and offers been made, Your Honor.
Mr. Howard, do you have anything, or do you not have anything that you expect you should have?
Not at this time, Your Honor.
All right, and so what I'm going to do then is I'll deem discovery status is held. Do y'all need something sooner? Because I've got it set for pretrial October 6th. If y'all got it worked out, do you need anything sooner?
And 6 works for the state, Your Honor.
It works for.
Okay. All right, then, Ms. Riggins, your next court date is October the 6th at 1:30. And so we will see you on that date.
Thank you, Your Honor.
Yes, sir.
Maybe excuse-
Yes, sir. For sure. Mr. Castleberry, you had a plea today, didn't you?
I do, Your Honor, and we're signed up, and I guess the state needs to sign up.
Okay. We're not, well, you gotta have a seat. They'll call you up in a minute to swear you. Kara Kopic. Already called that name, didn't I? The only one I haven't called is AC Haley. AC Haley. Cause number CR 21-0434-392, the state of Texas versus AC Haley. He's got it Saturday, September 2nd. It's supposed to be automatic. Apparently, it's 7:35 p.m. on Saturday. All right, is there an AC Haley in the courtroom? I see no one. I hear no answer. There's not an AC Haley appearing via Zoom. He's not in the lobby. The time is now 10:05. The docket was set at 9 a.m. The court will entertain a motion. Granted a capious issue, he'll be held with no bond. Again, I'm here all day. Yes, sir. Thought we were having a hearing.
We're not through with this.
Yeah, we're not done with him.
I think he just stood up.
Started off a little slow. It's mine. Almost like we know what we're doing. Only took 5 years to do it. If you could tell Trinidad PD, I don't mind signing warrants, but if it's a Snapchat warrant, or a cell phone they already have. I don't need to sign that at like 10:30 at midnight at night. It's that, because he ain't gonna do anything with it anyway. You see that Snapchat war? I told him, I'm like, look, if it's an emergency, I don't mind. But, Snapchat, you're not gonna mail it tonight. Mr. Presswood, you passed your test. You're free to go. Yes, sir. You don't have to be too mean about it. I didn't want to give him a hard time. I know you did. Well, because the last time was a cell phone and it was like 12 at night. It was already there. I guess I know who our fan was. Charlotte Myers. Yeah. Yes, ma'am. You're all right. I can hear it now, or it doesn't matter to me. I'm here all day. You ready? All right, Mr. Bennett, come on up now, sir. All right, this is cause number CR 21-0751-173, the state of Texas versus Ryan Patrick John Bennett. And this was set for a plea today, and a plea has been presented to the court in counts 1 and 3 of that indictment. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Bennett,
Defense is ready, Judge.
sir, is your name Ryan Patrick John Bennett?
Yes, sir.
And are you the same person that was originally indicted by Henderson County on these 2 counts of state jail felonies in that indictment?
Yes, sir.
If I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Bennett, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, we could have certain negative immigration consequences. Do you understand that? And Mr. Bennett, have you ever been treated for any mental health or emotional issues?
No, sir.
But do you understand what's going on in here?
Yes, sir.
And Mr. Castleberry, do you believe your client is competent?
I do, Your Honor.
The court finds that he is. Mr. Bennett, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, thank you.
But do you understand the charge?
Yes, sir.
Indicted in counts 1 and 3, those are both state jail felonies, and each of those carries a punishment range of not less than 180 days and up to 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand the range of punishment on each
Yes, sir.
case? In the plea bargain?
The state is recommending 2 years probation for 5, $1,000 fine, $750 attorney's fees, $355 court costs, $400 restitution, and all special and standard terms and conditions of probation. This would take into consideration counts 2 and 4 of the same charge, the same case, as well as unindicted credit card or debit card abuse from June of last year and theft of property from June of last year.
Is that your understanding of the plea bargain, Mr. Bennett?
Yes, sir.
Is that your understanding, Mr. Castleberry?
It is, Your Honor.
Well, Mr. Bennett, a few minutes ago, you told me you could read and write the English language. Is that correct?
Yes, sir.
I'm gonna go over some documents with you. The first are the agreed plea recommendations. Same indictment, but one for each of those counts you're gonna plead guilty to. Did you read and go over both the front and the back of those documents from Mr. Castleberry? And did you sign the front and the back?
Yes, sir.
You have any questions about it?
No, sir.
The next document I'm going to show you here is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Castleberry?
Yes, sir.
And do you have any questions about it?
No, sir.
And did you sign it?
Yes, sir.
Well, if you read and went over these documents with Mr. Castleberry, well, let me ask you if you have any questions about any of the documents you
No,
signed.
sir.
Well, if you read and went over these with Mr. Castleberry, I know he explained to you that you have many constitutional rights, including the right to trial by jury in each of those counts. You understand that?
Yes, sir.
Do you want a jury trial?
No, sir.
Do you want to waive that right and enter into these plea bargains with the state?
Yes, sir.
And I'll ask you, sir, in cause number CR 21-0751-173, in count one of that indictment to that state jail felony, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
In that same cause number in count three to that state jail felony, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I hear the evidence in each case.
State presents the offense report and the micro-mortgage compliance, Your Honor.
And no objection, Your Honor. Admitted.
State precedent closes, Your Honor.
Defense risk closes work.
All right, Mr. Bennett, based upon your guilty plea and the evidence in count one of that indictment, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense. The court will follow the plea bargain, considers these unindicted and indicted cases that are listed on the agreed plea recommendation and sentences you to 2 years in a state jail felony facility. However, the court will probate that, places you on community supervision for 5 years. You do have 70 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and abide by all the regular and special terms and conditions of community supervision, including this $400 in restitution. Now, as to your guilty plea and the evidence in count three, court has enough evidence to find you guilty and does find you guilty of that state jail felony offense in count three. The court again will follow the plea bargain, sentences you to 2 years in a state jail felony facility. However, the court probates that for 5 years, places you on community supervision. You do have 70 days credit as to any sentence you may eventually have to serve. Orders you to abide by all the regular and special terms and conditions of community supervision. And of course, this case will run concurrently with count one. And Mr. Bennett, have you ever been on probation?
No, sir.
All right, there's a lot of things you have to do and a few things you can't do on probation. You understand that?
Yes, sir.
You know what can happen to you if you violate any term or condition?
Yes, sir.
What can happen?
Prison.
You can go to state jail.
Yes, sir.
And you know how state jail time is served,
Yes, sir.
day for day. Here's what can happen. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest. You'd be held in jail without bail, brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you to state jail. You understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by
Yes,
this.
sir.
I hope you do, sir. Good luck to you. You see Mr. Halbert over here to your right. Have I signed a release?
And by tradition, Your Honor.
Yes, sir.
Good to see you again.
Good to see you. Yes, sir. There is. That's why I asked. Release of confinement. Is he being held on anything else?
There was no release of confinement.
How come I say it and they look at me with deer in headlights and then you say it and they're like, well, good. I guess about it. It's like Kevin Lee runs things around here, I'll tell you. And so that leaves everything except, well, we got a plea, and then we got another plea she's going over paperwork on, and then we've got this writ from Mr. Green. We're ready whenever the court is. Let's go ahead and get started because I think Ms. Moore is talking to her client there in the back. This is bond, so it's not probable cause, right? Is that correct? Okay, this is CV 20, come on up, Mr. Bond. CV 21-0480-392, ex parte James Bond. And this is set today for a writ of habeas corpus seeking bond reduction on behalf of the applicant. Mr. Green, are you ready? We're ready, Judge. On behalf of the state?
State's ready, and we will have one witness showing lobby.
Okay, and are we going to hear testimony from your client for the limited purpose of bail, Mr. Green?
No offense, but
You need his britches pulled up?
they're about to fall down, Your Honor. I can't.
You losing weight in the jail?
Yeah, about 70 pounds.
Probably not the ideal plan. We good now? And are we going to hear testimony from your
We
client?
are, Judge.
All right, Mr. Bond, if you can raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. And again, for the limited purpose of bail, Mr.
Please,
Green.
Judge. You are James Bond. Is that correct? And you are currently in the Henderson County Jail. Is that correct?
Yes, sir.
And you have been continuously confined in the Henderson County Jail since June the 8th of 2001.
Yes, sir.
2021, I'm sorry. You are currently held on 3 felony charges,
Yes, sir.
and one of those is online solicitation, correct?
Yes, sir.
And that bond is currently set at $300,000.
Yes, sir.
You're also confined on a felony charge of stalking, correct?
sir.
And that bond has been set at $150,000.
Yes.
And
Alleged fines.
right. And you're also being held on an aggravated assault charge as well.
Alleged, yes, sir.
Yes. And that's what's called a charge, not a conviction. And that bond is also set at $150,000.
Yes, sir.
Fair statement that you cannot make those bonds.
No, sir.
If you could have made those bonds, you would have made them long before now.
Yes, sir.
And that you don't have any financial means yourself to make those bonds.
No, sir.
And in fact, you've been determined indigent by the court, and I've been appointed to represent you.
Yes, sir.
Mr. Bond, you have lived in Henderson County since 1978.
Yes,
Is
sir.
that correct?
Yes, sir.
And during that time, you've lived in both Payne Springs and where else?
Gunbarrel City.
All right. And when you were arrested, you were living where?
It's actually in Oak Harbor, which is the county. Tanglewood, Oak Harbor and Tanglewood Shores.
Okay, and that's over in the Gun Barrel City area.
Yes, sir. But it's actually county, yes.
Yes. And you live there with who?
My mother, and she stays there, and sometimes she don't. She has 2 houses she stays at, and sometimes I watch that one.
Okay, and how long have you been staying at that location in Oak Harbor?
Since my dad died probably 5 or 6 years ago, on and off, and then finally I just moved in there because it was too much trouble going back between 3 houses.
Okay. If your bonds are reduced and you make bond and you get out of jail, that's where you'll be returning.
I can go there, or I can go to her other house, either one, which is out in the woods.
Okay, and where is that specifically?
It's some county road here, way outside Athens, past the Andrews Center.
Okay, back towards Palestine.
Yes, sir.
Okay, and your family owns that house?
My mother is either going to trade the one she has for that one or the other one, so it's kind of in the air which one she decides to go with.
But you do have somewhere to go.
Yes, sir.
And your mother's name is what?
Jimmy Lynn Bond.
And how old is she?
I'm going to say 65 to 70. She has double stage 4 breast cancer in both breasts.
Okay, and how long has she lived in Henderson County?
Well, we all lived here since 1978.
Y'all came at the same time. Okay. Mr. Bond, if the judge sets conditions of bond for your release, you willing to comply with whatever he asks you to comply, whether it's checking in with a pretrial release officer, taking drug tests,
That's
avoiding
fine. I don't do drugs.
avoiding the people that have made these accusations against you, those kind of things.
Yes, sir.
Okay. As far as Any felony convictions? Do you have any felony convictions?
None I'm unaware of.
Okay,
I've had a concealed handgun license for 20+ years,
okay. And still, and is that still current?
as far as I know.
Okay. Pass the witness shot.
Ms. Pace?
Thank you, Your Honor. That Oak Harbor address, that's where you were living right before your arrest?
Yes, during the arrest, yes.
And that is directly next door to the named victim in this case, correct?
There's 2 houses there. It could be either or. She has 2 houses there. And then we have the one in the woods on the county road out here in Bethel Anderson.
And the named victim in this case lives next door to the Oak Harbor homes that you were
To
talking
the
about.
newest one, yes,
And
but I don't have to live there.
at those homes, you also have a surveillance system, right, where you can see what's going on
It's
outside?
just a cheap $40 camera from Walmart that goes to your Wi-Fi.
But you can see what's going on outside, right, Mr.
Yeah,
Bond?
on the road. It's pointed to the road.
Do you have anywhere that you're working, Mr. Bond?
Well, I just got let go from a job or quit a job at Captain D's because they have too many people. And they didn't need me and 15 or 30 other people.
And do you have any savings accumulated from working or from any other source?
No.
So what kind of bond do you think that you might be able to make?
I don't know, just I know it can't be this ridiculous. I mean, this is just way too high.
Have you spoken with any family or friends to help you make?
Well, my
bonds?
mom can try to help me, but I mean, nobody has this kind of money just laying around their pocket, at least I don't.
Mr. Bond, have you spoken with anybody about attempting to help you make bond?
My mother done came and talked to the sheriff and talked to him about it, and he told her I was going to prison.
You don't know what anybody in your life can help you do as far as.
My mother and sister can try to help me. As long as I'm in here, because I can't do anything while I'm in here.
Mr. Green?
Mr. Bond, you have family that can help, but they can't help you make $600,000
No,
worth
sir,
of
they
bonds.
couldn't if their life depended on it.
I'll pass the witness shot.
No further questions for this witness, Your Honor.
I've been here for 83 days.
Oh, I think did I sign the arrest warrants?
Yes.
Believe so, Judge, yes.
All right, and just so everybody's clear, and Mr. Bond, did my wife ever represent you
Yes, sir, she did.
years ago, right?
Yes, and I let her go because she didn't file any motions for me, and I sat there for 76 days.
Yeah. Yeah, I don't know if I'm gonna recuse myself from this case. Mr. Bond and I shared words over the way he talked to my wife, and I just could not be fair and impartial. And I didn't remember that until after. made the
I hope that
connection.
you didn't hold it against me, but there's nothing I could do.
I'm not going to, which is why I'm gonna recuse myself, because it wouldn't be fair to you. And I know, I'm sorry, Mr. Green, but
And
I remember that now.
And just for the record, we both go to Life Fellowship.
Right.
Well,
Understand, Your Honor.
I guess.
You filed a grievance on my wife. I mean, I think
No, I'm not-
it puts the court in a bad position. It puts you in a bad position.
It's a
Mr. Bond.
conflict of interest, right?
I was just trying to figure out I guess, I mean, I was gonna say
Yeah.
we could recess the hearing, but
And I
we
should have
can't
said that
because
before you
it's-
started, but it's all kind of dawned on me, if I remember, because I've known Mr. Bond for years, but now I know, I remember why.
so that you need to refer that to Judge Charles.
It technically has to go to him before, I can't do anything else. So,
Yes, sir. Okay.
Can I say something?
well, if it's about my wife, I'd appreciate you not.
No, it's not.
Okay.
I'm innocent of all these charges.
I
We
don't
know
presume you any other way but innocent, but you're in jail and I get that.
For 83 or 4 days.
I'll get that done. We'll get that done today.
Thank you, Your Honor.
Yes, ma'am.
So what that means is because he can't hear it, he's referring to what's called an administrative judge. His name is Charles. So if it would be him,
Well, we got a plea. And we're still waiting on paperwork on the other, I guess. I swear to God. He's been in that court before. All right, Ms. Moore, I think you're finishing up stuff. Are you ready on this topic?
Yes, I realized that we were missing one document that was in Mr. Morgan's paperwork, and I don't think we got it on this topics. It's the order considering the, do you have one?
I'm looking. I do have a release of confinement. I do not have the
So
order.
We can. we just need-
Yeah, I'll just sign it.
Okay.
Yeah, because they're unindicted misdemeanors or unfiled misdemeanors. Misdemeanors can be indicted. All right, this is cause number CR 21-0436-392, State of Texas versus Kara. How do I say your middle name?
Lene Kopic.
Lene Kopic. All right, set for a plea today. A plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Kopic.
And we're present, Randy, Your Honor.
All right, ma'am, is your name Kara Kopic?
Yes.
And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of prohibited substance in a correctional facility?
Yes, Your Honor.
And get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You can lower your hand. Ms. Kopic, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Kopic, have you ever been treated for any mental health or emotional issues?
Sir.
Do you understand what's going on in here?
Yes,
And Ms. Moore, do you believe your client is competent?
I do.
And the court finds that she is. Ms. Kopic, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But you understand the charge.
Yes, sir.
Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range of punishment? And the plea bargain?
The state is recommending 5 years, probated for 5 years, $2,000 fine, $975 attorney's fees, $305 court costs, all special and standard terms and conditions of probation, including $180 of restitution. And this offer would take into consideration 2 unindicted cases, 1 for PCS, less than 1 gram, and 1 for possession of marijuana.
Is that your understanding of the plea bargain, Ms. Kopic?
Yes, sir.
Is that your understanding, Ms. Moore?
It is, Your Honor.
Well, Ms. Kopic, a few minutes ago, you told me you could read and write the English language. We'll go over a couple documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Ms. Moore?
Yes, Your Honor.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? Did you sign the second page? Do you have any questions about it? Do you have any questions about any of these documents that you read and went over with Ms. Moore? If you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes, sir.
Do you want to do this plea bargain?
Yes, sir.
Then I'll ask you, man, how do you plead to that third-degree felony offense of prohibited substance in a correctional facility as alleged in the indictment?
Guilty.
And are you pleading guilty because you are guilty and for no other reason? I hear the evidence.
And state presents offense report, lab report, and Michael Morton compliance charter.
No objection.
Admitted.
State rests and closes, Your Honor.
Yeah, we rest and close. Ask the court to follow the plea bargain.
All right, Ms. Coppock, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense. The court will follow the plea bargain, considers those two unfiled cases and unindicted cases, and sentences you to 5 years in the Texas Department of Criminal Justice. However, the court will probate that, follows the plea bargain, places you on community supervision for 5 years. You do have 28 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and abide by all the regular and special terms and conditions of community supervision. Ms. Coppock, have you ever been on probation
I was on pre-trial for 12 months in Cherokee County 12 years ago.
in Cherokee County? And did you successfully complete it? So you know what it takes.
Yes.
Do you know what can happen to you if you violate this probation?
I don't want to do this.
What can happen?
Go to jail.
For how long?
5 years.
That's correct. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be held with no bond, brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you to 5 years in TDC. You understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by these.
Extremely important.
I hope you do, man. Good luck to you. You need to, now that you've been finally convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions, consult an attorney. Good luck to you, ma'am. I signed your order of release, but you got to go back and book out and you need to see Mr. Halbert and probation.
Kevin will be proud of us. We got Mr. Morgan's paperwork ready.
He's been grumpy today.
Did not want us coming back.
He's always grumpy. He's been especially grumpy today.
So I think y'all have a big docket today and tomorrow.
We do. We do. Are we ready on Mr. Morgan?
Yes.
All right, this is cause number CR 21-0383-392, the state of Texas versus Raymond Alonzo Morgan. We held discovery status earlier. However, now a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Morgan,
We're present ready, Your Honor.
sir, is your name Raymond Alonzo Morgan?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the second degree felony offense of possession of a controlled substance?
Yes, sir.
And get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir.
You can lower your hand. Mr. Morgan, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, you have certain negative immigration consequences. Do you understand that?
Yes.
And Mr. Morgan, have you ever been treated for any mental health or emotional issues?
Yes.
Do you understand what's going on in here today?
Yes.
And Ms. Moore, do you believe your client is competent?
I do, Your Honor.
The court finds that he is. Mr. Morgan, I know you've already been arraigned on this case. However, Would you like the prosecutor to read the indictment against you out loud here in our courtroom?
No, sir.
But do you understand the charge?
Yes.
Well, as indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range?
Yes.
And the plea bargain?
3 years TDC, $900 attorney's fees, $365 court costs, and $180 lab fee, Your Honor.
122 days credit?
Yes, Your Honor.
All right. Is that your understanding of the plea bargain, Mr. Morgan?
Yes.
Is that your understanding, Ms.
It is,
Moore?
Your Honor.
Mr. Morgan, a few minutes ago, you told me you could read and write the English language. I want to go over 2 documents with you. First is the agreed plea recommendation. Did you read and go over both the front and the back with Ms. Moore?
Yes.
And did you sign it?
Yes.
Any questions about it?
No.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with
Yes.
us? Sign that second page.
Yes.
Any questions about it?
Yes.
Any questions about any of the documents you read and went over with her?
No.
Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
You want to do this plea bargain?
Yes.
And I'll ask you, sir, how do you plead to that second-degree felony offense of possession of a controlled substance? Are you guilty or not guilty?
Yes.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
State presents an offense report, Michael Morton compliance, and lab report, Your Honor.
No objection.
Admitted.
State rests and closes, Your Honor.
Your Honor, we'd rest and close and ask the court to follow the plea bargain.
All right, then, Mr. Morgan, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense as alleged in the indictment. The court will follow the plea bargain, sentences you to 3 years in the Texas Department of Criminal Justice with credit for 122 days and orders you to pay your attorney's fees, court costs, and lab fee. And Mr. Morgan, a couple more things. Now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, you need to see an attorney. And lastly, sir, have you had an opportunity to review the judgment in your case?
Yes.
Was your name, the charge, and the time credit correct?
Yes.
All right, sir, you're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you, sir. Need to see Mr. Halbert.
Mr. Morgan was asking if we could get a copy of his judgment.
We'll get you a copy of that, Mr. Morgan, before you go.
And that's all I have till this afternoon.
Yeah. Like she caught me right on time.